Today we'll be taking an in-depth look at one of the rules of the game, or properly put, the rules of evidence. Because as you see to my right, if you sit on your hands during trial, sometimes that can be fatal. Now today I'm going to cover Rule 615. The case illustrating this rule involves a termination of parental right. Now apparently at the first stage hearing, which is the unfitness hearing, there was a potential witness in attendance. The respondent's attorney made a motion to exclude that witness. The judge granted it in part. He had the witness leave during certain testimony, but allowed that person to return later on. This witness later testified at the second stage, which is the best interest hearing. On appeal, it's argued the judge had no choice under Rule 615 and should have excluded them. Now, evidence Rule 615 at first glance suggests such a request to exclude witnesses has to be granted, which sort of makes sense. If a witness gets to watch proceedings, what they might hear could impact their testimony later on when called. And the court can also, in some circumstances, go a little bit farther than that. They can actually order excluded witnesses not to discuss the case with other potential witnesses. Now, these motions can be made at any time. Often they're made before the commencement of trial, because sometimes you never know who's going to show up out of the blue and want to testify. So the question is, does the denial of such a request mandate a reversal of the trial court's decision? Well, the appellate court points out that prior to the enactment of the 2011 rules, case law left it in the court's hands, which actually made it discretionary. Now, the appellant says, hey, the federal version of this rule makes it mandatory, so why can't we do the same here in Illinois? And the appellate court, in response, points out that actually federal rules have the same exceptions. The appellate court also points out that the committee commentary makes clear that Rule 615 was not designed to alter long-standing case law on that issue. So the bottom line is that the court sticks with the case law. A judge can deny a motion to exclude witnesses, but there are a few caveats with this. If you have a court reporter, the court should indicate why it's denying the motion. And if you're ever appealing that issue, you may need to show with specificity why having that person sit in the proceedings prejudices your client's case. Anyways, that's all I have. If you want more of these commentaries, feel free to subscribe because, hey, they're free.